We have been talked about alternate dispute resolution in many fields. So I've been asked to throw some light on the alternate dispute mechanism in the taxation laws. Next, please. There are 4 federal laws wherein this provision is available under the Income Tax Ordinance, under the Sales Tax Act, the Federal Excise Act, Customs Act, and the last one being the Provincial Act. I have just mentioned this because we are in province of Sindh right now. Settlement concept was way back introduced in 1996 in the Sales Tax Act, and an indirect settlement commission was formed wherein any aggrieved party could approach for settlement of its cases. The commission was consisting of 3 members nominated by the government, but as far as my experience shows, that commission wasn't a very good success for its limitation and perhaps lack of knowledge for the taxpayers, and ultimately in 2000 this was omitted. Then in the year 2004, it was introduced simultaneously in all the federal laws by way of insertion and amendments respectively in the Customs Act, whereby section 195C was introduced, section 134A in the Income Tax Ordinance. This is now very important section because it's now applicable after its amendments to the remaining laws as well. Section 47A was also introduced, and likewise section 38. This 2011 Act was promulgated by the province of Sindh, and at the time of promulgation, section 65 was incorporated as a mechanism for alternate dispute resolution, and this provincial law is more or less follows the federal law. Now the mechanism was that it operated side by side with the existing conventional laws, had some simple procedures, was an opportunity for the taxpayers to have recommendation from independent experts, and it was an out-of-court settlement with the tax collector. When the law was when the law was introduced, it had various drawbacks, and from time to time required amendments. So the first drawback which is noticed is that the decision of when the matter was referred for any dispute resolution, the decision arrived at was to be accepted by the FBR, and it was also empowered not to accept it or to modify it, and resultantly, as and when the same was not accepted by FBR in its totality, it gave a further ground of appeal to the taxpayer. Secondly, the ADRC committees were then headed by the FBR officials, and it was the main contention of the taxpayers that they are not serving useful purpose because of their inclination towards their own department. In 2018, some corrective measures were adopted, and the most important was that the decision of the ADRC committee was now made binding on the parties, and this was a very important amendment, and was required long ago. At the same time, a mechanism was evolved that the taxpayer was also required to withdraw its pending cases from the court. And then in 2020, while going for some dispute resolution, the aggrieved party or the taxpayer was required to first make an offer for settlement that this much amount of tax is payable and this is not. And then once the offer was made for constitution of a committee, the taxpayer could not retract from the offered amount of tax. In 2022, some more amendments were carried out, and now only such cases were referable for ADRC in income tax, sales tax, and federal excise matters where the amount was 100 million and above. So this was like a threshold for referring matters, and only high stake tax cases were being then referred for ADRC. The decision was still binding, and the parties were required to withdraw their cases. Now, through this amendment, the department was also required to withdraw its counter cases, if any. And another amendment was introduced, which was very beneficial to the taxpayers and was a kind of incentive to them, that if they approach FBR for appointment of a resolution committee, and if the same was appointed within the stipulated time period, then the proceedings of recovery were automatically stayed till such time the committee has arrived at a decision, or the committee even has failed to come to a decision and has been dismantled. So this was a very important incentive for the taxpayers to go for ADRC. Now, what kind of matters were to be referred? There were some restrictions, some qualifications. The one was of the amount, which has now been reduced in 2024. The other requirements were that your case must be pending before some forum, from appellate authority, original forum, or any court of law. Only such matters can be referred. Criminal proceedings were accepted. You can't go for any ADRC where some proceedings of FIR are pending. And lastly, where any interpretation of a question of law is involved, which naturally rests with the courts to decide. So these were the disqualifications. Now, the matters which are referred to ADRC, now the question comes that if a question of law cannot be decided, what is to be referred? So basically, it is like the actual facts which have been ascertained at a certain level that are to be resolved, like some calculation issues, some factual determinations that the taxpayer has already paid his taxes and those have not been accounted for in the orders by the authorities. And then the burden was upon the applicant or the taxpayer to come up with his explanations and make out a summary for his case, that what has been already agreed, what is disputed, what evidence is being produced, what is his contention to get his matter resolved, and why it should be resolved in his favor. The constitution of the ADR committees has been a very big question and has been debated since it was introduced in 2004. As initially I said that they were headed by the FBR officials, and then the role of the taxpayer in its formation was minimum, and in fact no role was allowed to be played by the taxpayers in the formation of the committees. Though there was a panel of members from amongst the business community, tax practitioners, lawyers, but still the taxpayer had no say in the appointment of the committees. So now finally what has been done in post 2022, that the committees are now to be headed by a retired judge, not below the rank of a judge of a high court as its chairperson. Ministry of Law is required to make out a list, and from amongst those judges, retired judges, a person has to be appointed as a chairman of the committee. The second member would be the chief commissioner or the chief collector having jurisdiction over the case, and now there is an option for the taxpayer to nominate a person from the panel already notified by the board, comprising of chartered accountants, cost and management accountants, advocates, retired officers of inland revenue, and reputable businessmen as nominated by the chambers of commerce and industry. Now apparently this seems to be a very good move, that the ADR committees have been reconstituted in a manner which are more impartial and are independent. But still, as from the taxpayer's perspective, there's still some room for his objection as to the inclusion of the person from the department and having a voting right as well. There's one view that though he can be nominated to assist the other members of the committee, but must not have a voting right to overdo or to stop the proceedings of the ADRC committee. So there can be some amendments be proposed that a member from the department can be there without a voting right, or maybe a person is, the committee is enhanced, the membership of the committee is enhanced by giving the taxpayer an option to nominate one person from his side as well. This is a matter which can be looked into by the FBR. Now recently, a Finance Amendment Act 2024, next please, has been introduced as recent as on 6th May 2024, wherein a number of amendments have been carried out in the taxation laws regarding pendency of the appeals and the forum where the appeals are to be heard and decided, and so on and so forth. But one important amendment which has been carried out is in respect of the ADRC system going on in the taxation laws. Now the governing law will be section 134A, which has been mutatis mutandis applied in the Sales Tax Act and the Federal Excise Act. Insofar as the Customs Act is concerned, section 195C is independently there, and it has like more or less similar provision. The limit is now reduced to 50 million for a dispute, which can be referred to the ADRC committee, but still it does not apply where criminal proceedings are pending, and the condition of initial offer for tax payment is still there. Now he is also required, the taxpayer is also required to give an undertaking to accept the decision of the ADRC committee. The most significant of the amendments, according to me, has been made is regarding the disputes of the state-owned enterprises, as just pointed out by Mr. Ijaz Ahmed. All along, we have seen in courts as lawyers, now as a judge as well, that most of the litigation coming into the court generally is from the state-owned enterprises, and very heavy stakes are also involved, especially in tax matters, and courts are required to decide a dispute between two parties which are like owned by the same person. And as I have said time and again at many forums, that it is like taking out money from one pocket and putting it into the other, and requiring the courts to interpret the law for them or to resolve the matters for them, and then at the end of the day making lawyers richer as long as this continues. So now it has been mandatory for the state-owned enterprise, next please, to go for ADR. Now the limit of 50 million will also not apply to a state-owned enterprise. They have to mandatorily go for ADR in tax matters, in all tax matters, including income tax, sales tax, federal excise. And the significant amendment has now been provided that, just Mr. Ijaz pointed out, that the officers running these organizations were always under a fear that if they take any decision in the management affairs, including settlement of cases, so they will be prosecuted by the government, the departments of the government, or maybe they have effect on their service carriers. So now they have been protected from any suit, prosecution, or other legal proceedings if they enter into any settlement of cases pertaining to the state-owned enterprises. And by state-owned enterprises, we all know the law has been promulgated in 2023, which is called State-Owned Enterprises Act 2023, which normally applies to the organizations majority owned by the government, or where they have the controlling shares and manage the affairs of the organizations by nomination of directors and executives. And finally, this compulsory and mandatory ADR requirement for the state-owned enterprises provides them a chance that if first they have to go for ADR, if ADR is not successful or the decision is against them, then they will have the option of filing an appeal before the appellate forum, whatever is available in law. So these are like the changes brought into the taxation system, and perhaps if the FBR can look into the reformation of these committees to the satisfaction of the taxpayers, so it will be more helpful and conducive to go for taxation for ADRC instead of going to the courts. Thank you.